couple had a bit of a ritual that they would take a short drive from their home to the city of Milo, Iowa, about 8 miles away from where they live, give or take, to go to the Casey's there so Shirley could get a cup of the leaded stuff. Well, on that morning when they got to Casey's, they ran into a family farming buddy. And that man asked Bill and Shirley if they would consider supporting him. He dropped Shirley off. He watched her get out of the car and walk up the driveway. What Bill didn't know, what he couldn't have known, and what in his worst nightmare he would have never fathomed, is that would be the last time he ever saw his wife alive. Bill then drove his pickup to where his semi was parked. His semi was already loaded with corn. Bill started his trailer, and then he drove to the Cargill plant in Eddyville, Iowa, so that he could unload his corn. We'll learn that on that morning, Shirley Carter made a phone call at 8:48 a.m. She called the Iowa Corn Board, and she asked for them to send a ballot, just like they said they would do when they saw their friend at Casey's. Bill, on the other hand, is then in line at 9:01 a.m. He's getting his corn that's in the back of his semi probed for moisture. And we're going to learn all about how it is that corn gets probed and how corn is dumped and everything else during the course of this trial. But the bottom line is Bill's having his corn probed at 9:01, and we know someone at the Carter household made a phone call at 8:48. Elsewhere that morning, about the same time Bill is dropping Shirley off at home, Jason Carter is dropping his son off at school. We'll learn that after that occurs, Jason then drives to where he keeps his semi. It too was loaded with corn. He fired his semi up, let it warm up, and then he drove to the same Cargill that on the same route that his father drove that day. Now, Jason got there later than Bill. And because of that, it took him longer to unload his corn. In fact, we'll learn that Bill is driving away when Jason is still in line. Now, we'll learn that instead of going home directly, Bill stopped in La Villa, which is another town near Eddyville, Iowa, because he wanted to stop at Casey's there to, I think if he tells us, to sneak a donut, get another cup of coffee, and use the bathroom. So what we're going to learn is on that morning, Bill Carter did not go directly home because he was making such good time. Because when he got to Eddyville, he literally pulled right in to be probed. And then, because he had dry corn, he drove right into dump. This trip down to Eddyville took significantly less time than he anticipated. So as a result, instead of driving straight home, he went and he reloaded his semi with corn, so that the next time that he needed to take another load down, that was already done. Just as he did the night before, and just had Mr. Carter had done the night before. We'll learn that Jason Carter left Cargill at 9:59 a.m. And he would later tell investigators that he drove his now empty semi back to where he parks it. He then hops into his pickup truck and drives to his parents' house. Now, the evidence will establish Jason Carter wasn't always a farmer. He worked other jobs in the past. And it wasn't until late 2014 that he quit his full-time job as a mechanic to try to make it as a full-time farmer. He opened his own business. We'll learn it's called Broadview Farms. But he didn't own any land. And what we'll learn is in the farming world, status tends to be related to land ownership. And not all land is created equal. There's good crop land, and there's inferior cropland. Now, Bill and Shirley Carter, they spent a lifetime acquiring good cropland. Their business was called Carter Farms. Now, we'll learn that about this time, with Bill and Shirley being in their late 60s, they were starting to slow down. They were starting to slowly step aside from that entire career that they had built. We'll learn that over time, Bill Carter actually went to some of the landlords that he cash rented land from and said, you know what? Would you let my son take over this lease? Will you rent to him instead? They weren't prepared to step aside entirely. That is, they weren't ready to retire and let Jason Carter have Carter Farms. And we'll learn, as I told you, Mr. Carter didn't own any land. Now, we're going to hear that there were times that he wanted to acquire land, but whenever land was available to buy, for whatever reason, it seemed that land was beneath him. And Jason Carter liked to spend his money on fancier, newer equipment, not on dirt. So you might be wondering, if Jason Carter couldn't run Carter Farms instead of his parents, why didn't he just run Carter Farms with his parents? And other people had that same question. We'll have the opportunity to listen to two different people who asked that very question. Why don't you run the business with your parents? One of the conversations took place years ago. The other, just the fall harvest before Shirley's death. Both times, Jason Carter, the man sitting in that chair right there, said he could never go into business with that bitch. So there was friction. Now, don't get me wrong. I'm not talking about throw punches friction. I'm not talking about never speak to your parents again friction, or even curse them out to their face friction. But there clearly was some friction. And for Jason Carter, at least, it appeared it was significant, and he had carried it for a while. Jason would later tell investigators that on the day of his mother's murder, he drove from Cargill back to where he parks his semi, got in his pickup, and drove straight to his parents' home. That drive is 53 miles. Some of it's at 65, some of it's at 55, and the last part is on gravel. Now, taking his word for the path he drove, law enforcement drove that path as well. And when they drove that path, it took 51 minutes. The evidence would suggest that the defendant would have arrived at his parents' home sometime before 11 a.m. And that dovetailed nicely with other evidence that we'll hear about. You see, police would eventually learn the defendant sent a text at 10:55 a.m. asking for chemicals to be delivered to refill a sprayer at his parents' home. The defendant's text stated the sprayer had less than 20% left in it, almost as if he's looking at a gauge. He said he needs the chemicals at the old man's place. Now, if the defendant was standing at the sprayer at 10:55, that would be right in line with the amount of time it took police to drive the distance. 53 miles in 56 minutes, because they're going to give him some credit for the amount of time it's going to take him to hop out of his semi and get into his pickup truck. The defendant would later tell police when he went to go inside his parents' home, it was getting towards 11. But it's 11:11 when the phone rings at the Marion County Dispatch Center. The defendant's the caller. He says he just found his mother lying on the floor. He sounds upset, very upset. And he says to the 911 "Dispatcher, there's blood everywhere." Later, that would seem odd to investigators because, as we'll learn, there was blood. But most of the blood is underneath Shirley's body and not something you see if you just walk in the door. We'll also learn that the evidence will establish that at 11:08, for some reason, the defendant called and talked to his sister 3 minutes before he calls 911. He said he found his mother dead. His sister was quickly just as frantic as the defendant was acting. She asked him, "Have you called 911?" And he said he had not, and he was resistant to the idea. His sister insisted, but he said it was too late. He said their mother was already cold and stiff. Is it a clue? Because aside from the oddity of a son not wanting to call 911 after finding his mother's body, he would later claim that he went right inside after arriving at the scene. But as the evidence will show, if he was on the scene, based on the normal time it takes to drive that route, and based on what time he sent the text message, that 11:08 phone call leaves a 13-minute gap in his timeline. Well, confused by the defendant, his sister hangs up with him, and she calls 911 herself. Unfortunately, she's more than an hour away. So when she calls 911, it's routed to the nearest dispatch center where she is. And unfortunately, they can't help her mom. Back at the murder scene, we'll learn that after the call, the defendant did follow his sister's advice. He did finally call 911. It was a short call, but after that phone call, the defendant's on the scene for another 8 minutes before anyone else shows up. Now, given the defendant's resistance to calling 911, his sister had no idea that he would call 911. So the fact that she was desperate to get him help, get her mom help, she ended up calling her dad and was hopeful that he, that being Bill, would be in the right jurisdiction. That when he called 911, he would be able to get help. When Bill got that call, he was already on the way home. He wasn't terribly far. So he takes the phone call, he calls 911, then he hits the gas. He skids into the driveway of his home at 11:18. By then, the defendant is standing on the steps of a deck or porch off the back door, talking on the phone again, which is odd. The defendant would claim that after finding his mother's body, he never left her side, praying that the message was garbled somehow, that perhaps his daughter was wrong when she called him. Bill rushes inside, and he finds his wife of 52 years dead on the floor. He looked at the defendant, and the defendant started pointing things out like if he was just seeing them for the first time. "Look, Dad, there's a hole in the floor. Look, Dad, there's a hole in the refrigerator." Later, that would seem odd to law enforcement because Jason Carter had already told the 911 dispatcher about the holes. The defendant asked Bill if maybe one of his guns downstairs went off. Accidentally. The defendant suggested that they go check. We'll learn that the two started to go check, but Bill didn't even make it all the way down into the basement because none of his guns are kept loaded. That thought is impossible. So he turned around and he went back up the stairs to be by his wife. The defendant then advised his dad, "Dad, it looks like someone's tried to rob you," referring to an office area just off the kitchen where there's a file cabinet knocked over and papers are knocked off and are in disarray on the ground. Later, that disarray would be an important clue because it was staged. It was an amateur's attempt to make the scene look like Shirley Carter had interrupted a burglary. But we'll come back to that. The defendant then suggests that Bill go check to see if his pistol's where it is. So we'll learn Bill goes and checks, and his pistol is up in the closet, just like it has always been. Bill comes back, kneels down by his wife, and kisses her head, saying goodbye one last time. The first official to arrive on the scene is an EMT, or emergency medical technician, who also is a state police officer. And coincidentally, it's also someone who went to school with Jason Carter and was one of his college roommates. So the EMT knew Jason and knew his family. The EMT checked on Shirley and quickly determined there was nothing that could be done to save her. And being careful not to compromise the scene, he took Bill and the defendant outside. Outside, him and the defendant talked. Now, the EMT hadn't seen any bullet wounds in Shirley because her clothing was covering her clothes. Her clothing was covering her wounds. So later, it would seem extremely odd to investigators that within hours of this crime, the evidence will establish that the defendant knew his mother had been shot. The defendant knew she had been shot with a rifle. The defendant knew been shot with a rifle owned by his father. Been shot with a rifle owned by his father during an attempted burglary, and the defendant knew been shot with a rifle owned by his father during an attempted burglary, and the shooter took the rifle with him when he left. The defendant knew all that before Shirley Carter's body was ever removed from the scene. Now, while the defendant talked to the EMT, Bill tried to figure out what happened to his wife and when it happened. At a glance, Bill could tell that Shirley had done chores that morning based on the condition of the farm. Bill knew she couldn't have been dead that long. First, Shirley had obviously started a fire in their burn barrel, and the fire was still burning. Secondly, she had put fresh sawdust down for the hogs that they kept on their property. Now we'll learn that Bill and Shirley at one time had a large swine operation, but they sold that off as they started to get older. But because of that facility, their grandson kept his 4-H pigs there, or hogs there. And we're going to learn about the fact that Shirley took incredibly great care of these hogs. It was truly one of those things that made her happy. And one of the things that she did was that she would feed the hogs, and while they stepped forward to eat, she'd scoop out all the manure and put down a layer of fresh bedding. When Bill goes down and checks the pigs, the sawdust hasn't been disturbed. The hogs just didn't have the time. Bill will also tell us that when he goes down, the pigs are still eating. You see, Bill will explain that he knows hogs. And when hogs start to eat, they get after it. They're not dilly-dalliers. He'll explain to us that a couple of the pigs that were there are gilts, which are female pigs that haven't had any babies yet, and that they were getting over being ill. So it took them a little bit longer compared to the barrows that just wolf it down. He said on any other day, and he'll tell us on any other day, those gilts took 35 minutes to eat. So when he goes down and checks and those gilts are still eating, and assuming Bill has been at the home 7 to 10 minutes, that means Shirley's been killed sometime after 10:50. And that was a clue. And it was odd to investigators because remember, the defendant has told his sister there's nothing he can do. The defendant tells his sister, Shirley's cold and stiff. He blurts out something similar on the 911 call, saying it looks like his mother has been there for 2 hours. But the EMTs and the first deputy on the scene will tell us Shirley's blood was still wet, looking like wet paint. And then perhaps in a better common sense measure of time, Bill Carter's hogs are still eating. Over the next several hours, predictably, friends and family start to arrive on the scene. One family friend sat with the defendant and asked, "What happened?" The defendant explained that he got to his parents' home. He went to the tractor sprayer, the same tractor sprayer he texted about at 10:55. The defendant said he started the tractor, engaged the PTO, and greased the zerts. Now we're going to learn that zerts are pivot points on farm equipment that need to be greased so they function correctly. Later, to investigators, that of course is an important clue because it fills the gap between when Jason Carter arrived at the home and when Jason Carter calls his sister. So they checked to see if the zerts were greased, and to their surprise, they weren't. In fact, farmers who work with this equipment every day will tell us it doesn't look like those zerts had been greased in a very long time. So the gap, it's still a gap in time. We'll also learn that the defendant told this same friend that when he went into his home, he saw his mother, saw the holes in the kitchen, not only saw that the office was ransacked, but he also said that he knew his parents' bedroom was ransacked as well. Like the office, we'll learn the bedroom did, at first blush, look like someone rifled through the drawers. But it's a clumsy misdirection and a clue. Despite the fact that someone tried to make it look like a burglary, the evidence will establish it wasn't. Shirley's jewelry box isn't touched. Her purse, that's wide open in the middle of the living room, anyone could see, that has cash, her credit cards, gift cards, and checks, not touched. Prescription drugs, including opiate-based drugs, in the cabinets, not touched. Guns, not taken. None of those things are missing. None of those things have been touched. The crime scene was staged. Staging in this case, as we'll learn, means that someone knocked things over to try to make it look like a stranger burglary when it wasn't. We'll hear from a world-class expert who will testify that this crime scene is a classic case of staging. We'll also learn that this amount of time that it took to do this staging is measured in seconds, not minutes. And this staging is one of the most important clues, because burglars don't stage crime scenes to look more like a burglary. Staging shows that someone wanted to make it look like a stranger burglary when it wasn't. Staging shows Shirley's killer wasn't a stranger. Staging was a clue, and a big one. So you might be wondering, if the guns, the drugs, the money, the jewelry weren't taken, what was? One, Bill will explain that Shirley, whenever she did chores, wore brown jersey gloves. When she'd come inside, she'd take those jersey gloves off, she'd drop them at the foot of the stairs. You open the back door, you literally take one step in, you take one step down, you're going down the back stairs. Those gloves would be resting on the top of the back stairs. Those gloves weren't there. They weren't anywhere. They were gone. Two, Bill kept a high-powered .270 caliber rifle in his gun safe and cabinet tucked away in the basement. That gun safe, like Bill's home, never locked. It would take a full day for this to come to light, but the .270 was missing, although every other gun in the same safe was not. Right after the crime, the defendant told law enforcement that his father owned a high-powered rifle. Unfortunately, the individuals interviewing Jason Carter that evening are not the same people who are the crime scene technicians at the scene. So although crime scene technicians can seize evidence that is there, they have no idea what isn't there. And so as a result, they didn't know to look for the 270. So the missing 270 is important, and it would become even more so down the road, because we'll learn a firearms expert looked at the bullet fragments from Shirley's body and the bullet fragments that were found in the home and determined those bullet fragments are consistent with a 270 round. And we'll learn that based on the weight of the fragments, there were only 2 shots fired. And as it turns out, that's just as the defendant told his brother on the afternoon of the murder. You see, right after the murder, the defendant's brother arrives on the scene. He'll explain to us that that day was a whirlwind of emotions, a blur. But there's one comment his brother made he will never forget. The defendant asked his brother, "Do you think whoever did this would have had to rack another round?" The thing is, they would and did have to rack another round. See, Bill's .270 caliber high-powered rifle is a bolt-action rifle, which means that the shooter does have to rack another round into the chamber to fire a second time. And that ejects a spent shell casing up and out of the gun and onto the ground. The third thing missing, the spent shell casing. Whoever racked the second round before they pulled the trigger a second time had the presence of mind to pick up the spent shell casing. Now, we'll hear experts call that policing your brass. It means that in the aftermath of a high-powered rifle shot in a small kitchen, the ringing in the shooter's ear, the smoke, the stench of gunpowder, a dead person lying at your feet, to have the presence of mind to pick up the spent shell casing. It suggests to police that someone who has that presence of mind is no stranger to gunfire. But at the end, the missing shell casing just beg a question. Who would have the presence of mind to police their brass? Now, the defendant would tell law enforcement that when it comes to guns, he knows how to load them and shoot them. But that would become an odd understatement and a clue, because the defendant's actually a quite accomplished hunter with a trophy room of kills in his basement. But how could anyone have gotten the gun, the gloves, and the casing away from the scene? To answer that question, we have to take a step back. The evidence will establish that on the day of his mother's murder, the defendant had 2 cell phones. A primary phone he used for business and to talk to his wife, his family, and his friends. And a second phone that only one person knew about. That phone was used to talk to one person, and one person only, a woman named Tara Hoke. On June 19, 2015, almost as soon as his son got out of the pickup to go into school, the defendant and Mrs. Hoke started trading text messages. It's about 7:43. Over the next 3 hours or so, they exchanged some 59 text messages. If you crunch the numbers, it's slightly over 3 minutes per text message for over 3 hours. And the defendant's second phone, it doesn't have a keyboard. It's one of the old flip phones, old-fashioned phones where you got to type in 3 letters or 3 numbers to get a letter. And it didn't matter if the defendant was in his personal vehicle or driving his semi filled with thousands of pounds of corn or waiting in line at Cargill. He was texting. In fact, we'll learn the very last text to Mrs. Hoke was at 10:50 a.m., and she quickly responded. But at 10:50, the defendant's text messages abruptly stop. And Mrs. Hoke will explain that that conversation wasn't in a logical stopping point. So at 10:50, something broke up the text every 3-minute pace. It breaks up 51 minutes after he leaves Eddyville, almost to the minute that it takes law enforcement to drive the route. And it breaks up just before his attention is shifted back to his primary phone, where he's asking for chemicals to be delivered. Looking back at the timeline, it was 13 minutes after the call to his sister that the defendant called the sheriff directly. Now, the defendant's call to the sheriff is cell phone to cell phone, so there isn't a recording of that call. But the sheriff will testify that when the call came in, the defendant was emotional, virtually impossible to understand, and it sounded like he was out of breath. The only thing the sheriff could make out clearly was, "They shot her." Later, the sheriff would listen to the defendant's 911 call, and he'll testify that the calls are notably different. And the difference is odd to him, because somehow the defendant was even more frantic, more hysterical sounding, and more panicked 10 minutes after he called 911. Yet the evidence will establish that in the minutes before and after the calling of 911, the defendant wasn't all that panicked or hysterical. You see, when the police later found out and asked about Mrs. Hoke and that second cell phone, the defendant stated that he remembered he left his second cell phone in his pocket and he needed to hide it. So in the midst of this emotional turmoil, in the pure hysterics of finding your mother, he steps over her body. He opens the door. He walks down the deck, goes to his pickup, opens the door, unlatches the hood, then walks around, opens the fuse box, and puts his second phone inside the fuse box. In this moment of pure turmoil, he had the presence of mind to hide his second phone. We'll also learn that traditionally, without any other reason to the contrary, law enforcement, when they search a vehicle, does not take apart the car in the process. Now, I'm going to wind this up in just a few moments, but there are a few parts I want to make clear. One, we have the burden of proof. When I walk into this courtroom, and this is the first time I've walked into this courtroom, but when I traditionally walk into the Marion County courthouse, or when I walk into any courtroom as the county attorney and I accuse a person of a crime, I have the burden of proof. That isn't a burden we will shy away from. It's one we fully embrace. But the scope of that burden is important, because our burden is to prove each and every element of murder, but nothing more. Which leads to point number 2. As with any attempts to recreate history, there are going to be questions we just can't answer. There are going to be parts of the timeline that I can't fill in. There are pieces of the puzzle that are missing. For example, I cannot prove to you that Jason Carter hid the gun, the phone, the gloves, and the shell casing in his vehicle. Because he just as likely could have stuck it somewhere on the farmstead. We're going to learn this is the home Jason Carter grew up in. It's the home that has many outbuildings, a pond, literally within a rock's throw. He could have put him there and just come back and got him later. But the reality is, our burden is to prove each and every element of murder, nothing more. So the next thing to keep in mind is, this was not a perfect investigation. No case was. Every law enforcement member who does this type of work would love to be able to Monday morning quarterback or to have a do-over or two. That's just the reality of everyday work, especially when it comes to law enforcement. We're going to learn that there was evidence that was missed by the crime team. We're going to learn that evidence that should have been taken on one night wasn't. It wasn't. It was a mistake. They will own that mistake. But it's important to keep in mind that any investigative misstep never changes what happened before the misstep. Doesn't change the truth as to what happened. And in the end, not a single investigative mistake will change the clues that lead to one conclusion. But as I said to you, they did miss some evidence. I can't hide that. I can't do anything with that other than to flat out tell you that there's a handgun, an old Civil War revolver up in a shelf. They didn't take it, the crime team. Downstairs in the basement, the gun safe, they seized all the guns, but they didn't take the safe. And in the bottom of that safe is a live .270 spent shell casing. They didn't take them that day. And they'll explain to you they made a mistake. But because of that mistake, it allowed the police to talk to Jason Carter again. And what he had to say was truly extraordinary. It's the perfect example of a silver lining. Because we're going to learn that the defendant insistently, repeatedly stated that before his mother's murder, he didn't even know there was a gun safe in the basement. He told them he never touched it, ever, to use his words. The claim that he didn't know there was a gun safe, the claim that he never touched it ever, would later seem awfully odd to investigators because, well, folks, it just ain't true. The evidence will establish Jason Carter and his wife bought that gun safe for Bill and Shirley. And Jason Carter's the one who put it together. His fingerprints were all over that safe. But they're between the walls of the safe, not in places that easily could have been wiped clean. We'll also learn that before this interview with law enforcement, the Carter family assembled at Bill and Shirley's home, trying to make sense of the senseless. During that gathering, the defendant asked his sister, would she go get him a flashlight because he wanted to go downstairs to see whether or not where the hole or defect in the floor, where it is underneath if you're looking up. Well, his sister will testify and tell us that that didn't make a whole lot of sense to her because you could tell the hole didn't go all the way through, but being a good big sister, she did what she was told, and she got the flashlight, and so she stood where that defect and started stomping. And after a while, she got tired of doing so because nothing was happening. So she walks downstairs. And to her surprise, the defendant isn't standing with a flashlight, shining it in the rafters. No. He started to walk to the room where the gun safe is. His sister will testify and will tell us that when she finds him in front of that gun safe that morning. Now keep in mind, this is the woman the defendant called before he called 911. This is a woman who he will later tell law enforcement someone he always looked up to. She'll tell us that Jason Carter said, Dad never logged that gun because it was so hard to get it out of the gun safe. Yet, less than 24 hours later, he'll be telling the law enforcement, didn't even know there was a gun safe. And equally confusing to law enforcement at the time. It's 6:08 a.m. on Sunday, June 21st, about 41 hours or so after the homicide. 43 hours or so. It's Father's Day, and the sheriff is awoken by a phone call from Jason Carter. Jason Carter asks the sheriff, did DCI, referring to the Division of Criminal Investigations, did they seize the 270? And the sheriff responds, I don't have any idea what DCI took. I wasn't there. When we give back the paperwork to your dad, when we released the home back, on the back would be a list of everything that was seized. Look there. When we listen to this evidence, ask yourself, why isn't Jason Carter at 6 o'clock in the morning calling to ask about the totality of the evidence? Why isn't he calling to ask, have you made an arrest? Why is Jason Carter only wondering if the cops have found the 270? Oftentimes at this point of an opening statement, you'll hear prosecutors talk about motive, means, and opportunity. Well, means, the 270 was in the home. There was ammunition. Opportunity, 13-minute gap in his timeline. So let's talk about motive. The reality is most farmers need and use a line of credit. The finances of farming is secular, and they can be enormous. A farmer puts a seed and fertilizer into the ground and then waits for Mother Nature to produce her bounty. And during that time, they sometimes have very little income coming in. So they live on their credit line. The trick is to live within your means. And we'll learn the defendant didn't do that. He splurged on new equipment. His spending was catching up with him. On the day of Shirley's murder, the defendant's business, Broadview Farms, had a credit line of $575,000. The defendant and his wife had signed personal guarantees in addition to farm guarantees, meaning the assets of the farm went first if you weren't able to pay your loan, and then your personal assets were next up. On the day of the homicide, their business account and their personal accounts both had less than $100 in them. And the credit line, it was nearly tapped out. The highest it had ever been borrowed against in the lifetime of Broadview Farms. And things were about to get a whole lot worse. See, we'll learn that in 2014, when Mr. Carter quits his job to make it as a full-time farmer, he's going to be farming, in his mind, slightly north of 2,000 acres. Well, in late 2014 and early 2015, he finds out that one of his largest landlords, who he rents land from, 750 acres worth, a third of his total operation, well, the landlord has passed away. And her son isn't interested in having the defendant farm the property anymore. He's just going to sell it. So just like that, poof, a third of his operation is going away. The other thing that we're going to learn is 950 of the other parts of the acre are controlled by his wife's stepmother. And the last part of the land, those are all the people that Bill Carter had gone to when he was starting to slow down to say, hey, will you let my son farm? We know that the 750 acres that went away was clearly on his mind that morning because his wife, Jason Carter's wife, sent him a text message showing the flyer advertising the land for sale just hours before Shirley's killed. Now, I want to go off script for a second because I want to make one thing abundantly clear. I am not saying Jason Carter was broke. To say that completely neglects to understand the economy of farming. I recognize that at any given time a farmer may have tons of corn or beans in their bins, and they simply go take the corn and drive it to Eddyville. And just like that, you get a check for a couple $1,000s. This case isn't about money, it's about pressure. It's about the reality of what's going to happen next. It's about, am I going to be able to be a full-time farmer? It's about whether or not my credit line's going to be renewed. This case is about pressure. It's not about dollars and cents. But by contrast, Bill and Shirley perfectly understood the realities of the farming world. Over their lifetime, they started with nothing, and they ended up with about $6 million in land. In addition to that, Jason Carter knew exactly what was in his parents' will. He was the executor. And because he was the only farmer, he got all the dirt when his parents died. In addition to that, he got a third of the liquid assets, which included $800,000 in a savings account. Was Jason Carter planning on killing both his parents that day? I don't know. Did his dad just not show up in time? I don't know. But I'm not required to prove to you why Jason Carter did what he did. I'm only required to prove to you that he did shoot and kill his mom. Now, we do know, at least from all the witnesses, it didn't appear Bill Carter and Jason Carter had the same type of friction that Jason clearly did with his mom. So could it be something as simple as, if mom's out of the way, dad, who's been showing me all along that he's willing to step aside and let me farm the land, is more likely to let me farm Carter Farms land? Again, I don't know. What we do know is this. A month before Shirley's death, Jason Carter, from his cell phone, sets up a new email address. His email address isn't in his name, his children's name, his wife's name, or Broadview Farms. No. Jason Carter sets up carterfarmsiowa@gmail.com. Now, could that be the reason? Perhaps. But the reality is, I have no way to prove to you what Jason Carter was thinking when he did it. And if you think about it, it makes perfect sense. One of the reasons why I'm not required to prove to you motive is there's absolutely nothing I can tell you that would make sense of why it is a son shoots and kills his mother. There's no good reason I can give you. And that's why the law doesn't require me to. The law requires me to prove each and every element of murder in the first degree. But you're going to find at the conclusion of this case that Judge McCall isn't going to tell you, I had to prove why he did it. And it makes perfect sense why I don't have to do that, because there is no good reason. What I can tell you is that what we will prove to you is that there are clues that lead to only one conclusion. And based on the evidence, at the conclusion of the evidence, we will ask that you return a verdict finding Jason Carter guilty of murder in the first degree. As the facts will support it, the law will compel it, and justice for Shirley will demand it. Thank you.